I'm still reading it, but since there was 1 minute left, I thought I'd come in, so I didn't go past the 16-minute time to be here.
Okay. Court's back in session.
Right, we will go back on the record. This is INJ 1700345 Emery Volva. We do have Ms. Gross back in the courtroom. Did you hand out completed form to my deputy, Ms. Gross? Ms. Gross, have you finished the form?
Yeah, I'm still going through it. It's 4 pages, and so some of these things are whatever. Okay, so now you know there's 2 minors in this case, right? Volva and Willoughby. It needs to be corrected on the record. Okay. Oh, sorry. One more page to put the same information. So after submitting this document, I'm going to be able to represent myself in this hearing. Is that correct?
We're still on the record. Excellent. We're going to take it step by step.
Okay. Well, I just want to make sure because it is my right to represent myself whether or not I turn in this document, but I'm doing my best to be as knowledgeable on this on the fly with the last 10 minutes. So here's this.
Thank you.
Am I, in the paperwork it says I'm to be at the table present sitting during the hearing, but I've never been permitted to be at the table during a proceeding. So am I able to now move and sit over there, or do I need to stay in the back of the room?
Right there, ma'am.
Just one moment.
right there.
You can come up to the podium. Actually, a lot of attorneys will come to the podium, but hold on, we'll take it step by step.
Okay.
All right, thank you for completing and signing this form. I am gonna order the advisement and waiver of right to counsel filed in this case. And you understand, Ms. Gross, if I do allow you to represent yourself, you will be held to the exact same standards and expectations as a licensed attorney.
I'm actually not held to the same stringent standards as attorneys who are licensed by the California State Bar. When I mention that I'm improper, that is notifying the court that I am not trained and have not been to legal school, but I'm accepting responsibility on my own legal account. So that's what that means.
Okay, Ms. Gross, I am going to hold you to the same expectations and conduct that I would an attorney. Do you understand that?
Absolutely.
All right. Do you understand that if you disrupt or delay these proceedings, you will either I will either remove the right for you to represent yourself because of delaying or obstructing the proceedings, or possibly you will be excluded from actually being physically present in the courtroom and would be allowed to attend telephonically. Do you understand that if you disrupt or delay these proceedings, your ability to represent yourself may be taken away?
I'd like to clarify that, Commissioner. Are you acknowledging if I object, is that being disruptive on the record? Because I would like to clarify that before anything happens. What do you define as delaying the proceeding? Because if I would like to object, or if I would like to intervene, or if I would like to say something on the record, I would like to know that that is not being misinterpreted as being a disruption when it is my necessity of my First Amendment right to speak.
Mr. Rose, I'm going to expect you to follow Welfare and Institutions Code Section 350 that states the judge of the juvenile court shall control all proceedings during the hearings. So I will control these hearings if you are willing to let the judicial officer control the proceedings without undue delay or disruption. I will allow you to represent yourself. Do you understand that?
Yes. Are you? You didn't answer my question
No,
about
I will
my.
not be answering
So
your questions.
okay. So are you saying okay? All right. Well, I will continue to be on the same good behavior that I have continued to demonstrate, and if I need to object on the record, I will, because it is my right representing myself. But yes, I will be on good behavior. We can proceed.
Okay, so the first order of business, Ms. Gross, because I am a commissioner, I am going to allow, yes?
I'm sorry to interrupt, Your Honor, but I don't know if prior to making the ruling on the request or the motion for self-representation, I certainly would like to be heard.
Okay. Well, I don't know that, I mean, what's your standing to be heard on it, Mr. Devane?
My standing to be heard on it, Your Honor, is that myself and my client are party to this action, as is Ms. Solis and her client, and the case law states that the right to self-representation in a juvenile dependency matter is statutory. It is not constitutional, and therefore can be and should be weighed against other factors that are present in the case, which include the dependent child's right to a permanent placement and as promptly and reasonably as possible.
Objection.
Right to have.
Okay, hold on. What is your legal ground for the objection?
Mr. Devane is making an invalid argument, trying to rebuke my constitutional rights to represent myself in this proceeding. He has no right to petition anything above my right to represent myself. Now, the last hearing, I asked Mr. Devane to prove jurisdiction, and he has still been able.
I'm going to ask you to stop, because what you're doing right now is delaying and obstructing.
How am I delaying?
Because
Can you please tell me exactly how I'm delaying? That way I can rebuke the behavior, because I'm participating in my hearing.
Correct. You are interrupting, and that is delaying.
How is he needs to prove jurisdiction, Your Honor. whether he likes it or not that I'm representing myself and that I have a voice of my own and that I'm a citizen of this United States and I have the right to represent myself in a juvenile hearing, criminal hearing, in a civil hearing, in any hearing in the court of law. Now, if Mr. Devane believes that his county interests, because of his plaintiffs and Ms. Solis and whatever else is involved, that is neither here nor there. He still needs to prove jurisdiction of why my daughter is unable to come back into my custody. Now,
Ms. Gross, please stop. You are disrupting and delaying these proceedings.
how am I disrupting the proceeding?
By interrupting and speaking when you are not being directed by the court to speak. So your objection is overruled. Mr. Devane, I've read the case law. She does have a statutory right to represent herself. She has clearly made that be known through many avenues. As long as she is making a knowing and intelligent waiver of her right to have an attorney, and as long as she does not delay and disrupt the proceedings, she has a right to do it.
Correct. And all I'm asking you is I'll make a brief record.
Okay?
She has been, is, and I think will continue to disrupt the proceedings. When we were here on September 7th, 2023, there was a hearing for confirmation of counsel for Mr. Valente. And I think I was present. I think she disrupted the proceedings. I think her behavior was
Objection.
close to
I think
contemptible.
Mr. Devane is trying to make excuses for not being able to prove jurisdiction last hearing.
Ms. Brooks, what is your legal objection?
My legal objection is that he's defamating my character to obstruct his ability to prove jurisdiction, what his job is as a county council representative of the plaintiffs.
Your
Ivan
objection is
Valenzuela
overruled.
and whichever CPS representative he's representing.
Your objection is overruled. Ms.
Why?
Brooks, I will not be answering your questions, Ms. Gross. Okay?
So you won't give me a state or federal ordinance or law that is rebuting my ability to challenge jurisdiction for Mr. Devane? And
Ms.
to
Gross,
allow him to defamate my character on the record to justify his inability to sustain a case on nothing?
Ms. Gross, you are disrupting these proceedings. Your objection is overruled.
I'm part.
Mr. Devane, you may continue.
Very simply, Your Honor, I believe she disrupted the proceedings at the 9/7 hearing earlier this afternoon. Prior to going on the record, we had a 5 to 7 minute exchange where the court had to ask Ms. Gross to exit the courtroom and come back in before we were even able to go on the record. I think that was disruptive, and I think here now this afternoon, as we have been on the record, she has been disruptive of the proceedings, and the case law says
Are
that
you incapable of
court
proving
can-
jurisdiction on the record, Mr. Devane?
Ms. Gross, stop.
it's a factor that the court can consider, and if the pro
It's
per
crazy.
litigant is going to continually disrupt the proceedings, it is a basis for the court to exercise discretion and deny the pro per motion.
Correct. Thank you.
Excuse me, objection. I really don't understand what you expect of a mother who's been deprived of her 2 children for the last 18 months when no harm has ever been done to the children, and all records of disproving the allegations from the caseworker that is here today I have in paper documentation, and I have served to all the parties via their bar association info. Mr. Devane, is your email address not up to date on the California State Bar?
Ms. Gross, right now, because you are not stopping, you are disrupting these proceedings. I am going to direct you to stop talking when I direct you to. So, at this moment in time, and I'm going to order Mr. Valente to stay in the courtroom because he's the last.
Excuse me,
attorney of
he's
record.
not the last, he wasn't even an attorney of record. You assigned him despite my objections and despite my affidavits. I don't understand what the obsession is with having Mr. Devane in the room or out of the room or having me have a representation or not. It's already been established I have the right to represent myself. Are we not able to proceed with Mr. Devane being able to prove jurisdiction? Is that not within his scope of practice as an attorney for the state of California?
Ms. Gross, stop. You are not controlling these
Okay.
Okay, so
All right.
at this moment.
Article 3, Section 1 says that you should be in good behavior at all time, and you should not be coercing my behavior for participating in this hearing as being improper, merely for participating in my hearing and advocating for myself and my children, who have been deprived of the ability of companionship, love, and the burdens and responsibilities that were awarded to me when I gave birth to my children. Now, Mr. Devane is representing Child Protective Services.
Ms. Gross, you are delaying these proceedings.
How am I delaying this proceeding by speaking about my case on the record?
Ms. Gross, because there's an order of the way we proceed. And
Okay, but procedural also states.
On the record,
She can't get two people at the same time.
And I want to make a good record for you. So I need one at a time to speak so that I'm able to get what you need to say and what the judge needs to say, because it's all important.
Okay, yeah, absolutely. I just don't understand why we're even debating any conversations until county council proves jurisdiction. And by me speaking on the record, judge or commissioner, I don't understand why you're saying I'm being improper behavior-wise. And I'm asking you to please tell me what I'm doing that's improper. That way I can stop. Because if you're saying I'm being improper, please define what it is I'm doing that's improper. I'm holding County Council, Mr. Devane, responsible for proving jurisdiction, or my children should be able to return to me today. My daughter should not be forced to live in foster care, and my daughter should not be forced to go between foster care and her maternal grandmother's house half of the time during the week, because Mr. Devane can't even prove why we're here. Why are we here, Mr. Devane?
Ms. Gross, stop. Do you understand that you are giving up the right to have an attorney represent you at these proceedings?
Why are we still talking about that? Why can't you move on to jurisdiction? I don't understand why we need to keep rebuting that I'm representing myself. What is confusing about that notion? Because Mr. Devane has demoralized my character because of the last hearing. I don't understand what you expect of a mother who's been deprived of her children. Why does Ivan Valenzuela have the authority to tell me that he will have me arrested and will pursue me with police if I attend my daughter's school functions, or if I try and visit her, or if I try to be in my daughter's life on a regular day-to-day basis? I've completed a case plan.
Stop talking!
Excuse me, Article 3, Section 1.
We're breaking.
Why are you...
We're coming back in 10 minutes.
10 minutes?
2:43.
Okay, well...
I need you to step outside.
Still have to prove it. No matter how long you make me wait, you still have to prove it. No, she yelled at me and kicked me out, which is fine, because it doesn't matter, because I will keep going in.